Hi, everybody. Todd Phillips coming to you live from Minneapolis for RE Journals. I am our corporate CFO and part-time webinar host. Today's topic is how COVID-19 is affecting real contracts of all kinds. So we'll talk about landlord-tenant contracts and other things that are affected, and then other legal issues we'll get into that you need to be aware of for this time. This is our Breaking Through the Disruption webinar series. Today we have JMarzo, Gould Ratner, Coyne, Chuhak Tecson, and Macey, Novack and Macey Law Firm, to get us through this topic today. Gentlemen, why don't you go around the horn and introduce yourselves, a little bit about your practice, quickly any issues you're seeing, and then we'll do some housekeeping items. Go ahead and go when you're ready.
I guess I can start. My name is Coyne. I'm the real estate practice group leader for the Chicago law firm Chuhak Tecson. Very heavy part of my practice is involves commercial lease negotiation. Obviously, the COVID-19 pandemic has caused a number of issues for our clients, raising a litany of questions regarding the enforceability of lease provisions. Certainly, a number of tenants have called to inquire about their obligation to pay rent, and a number of landlords have called to inquire about forced revisions on folks who are having issues paying their rent due to the crisis. Thank you for having me today. I look forward to today's discussion.
Go ahead, Joe.
Okay, thanks. I'm Joe Marzo. I'm a partner in the real estate group at Gould Ratner. Like Kevin, a large part of my practice focuses on commercial leases, both on the tenant side and on the landlord side. I also do some financing work for local banks and for borrowers. And so we have certainly seen, just as Kevin said, a raft of calls, questions about how leases are going to work in present circumstances and what kind of relief can be offered.
Hi, group. Macey. Thanks for inviting me. I appreciate Real Estate Journal giving me the opportunity to shave and put on some decent clothes today. I am our firm is a commercial litigation boutique, been around for 35 years. I've been in practice for 41. We have 32 lawyers dedicated to commercial litigation. We represent over the years and continuing commercial landlords, commercial tenants. We represent investment pools that are private equity firms where their funds invest in real estate. We invest in, we represent creditors. I'm getting some feedback. I don't know why, Ty, but we represent creditors in bankruptcy and real estate transactions for adequate protection issues and lifting the stay. We represent contractors and subcontractors involved in construction issues involving real estate, and we represent buyers and sellers in real estate asset purchases. And we also represent, believe it or not, remainderment and remainderment interest transactions. So that involve litigation with people who have, long-term leases in those properties. So that's what we do. Thank you.
Excellent. Eric, I'm getting you some triage on your feedback issue there. We'll have somebody text you in a moment. Let's do a couple housekeeping items real quick. We've got 300 people signed up, 312 people signed up today. So connection shouldn't be a huge problem, but if it is, so at the top of your screen, you're going to see a reconnect button. That's the best way. If you see somebody freeze up on your screen or your audio freezes up, push that reconnect button, and that usually fixes just about everything. If it doesn't, make sure you try to use Google Chrome if you have that. Last option is sometimes it works to just close out your browser and reconnect. But right now I'm showing 100% signal from everybody, and the server's not overwhelmed, so we should be in good shape for the duration. On the right, if you're on your computer, or below you if you're on your cell phone, you'll see polls and chat functions. I'll get a poll up in a few minutes, but on the chat, what I want you to do is enter in your name, company, and state that you're in so that we can all network with each other sort of on the side. Also, If you have questions, this is the place to put it, in the chat box. You can mark it as a question. It makes it easier for me to find it. But if you ask questions, I'll make sure that the panelists get those questions. That's it for polls and our chat. Special thanks to our sponsors today. All of the gentlemen on the phone and their law firms have respectively been great to work with for us. So don't forget to support Gould Ratner and Chuhak Tecson and Novack and Macey. Okay, with that, all of that said, gentlemen, let's get started. Let's maybe start with where are we at today, going back to March 16th? What has happened to our market from a legal perspective, and what has that brought us to? You're up, Joe. I heard you breathe.
All right, I started to move. I'll go first. So I think from a legal perspective, all transactional attorneys can take a look at what's happening in the deals they're working on and whether leases are going forward. So thinking back to the middle of March, I had several leases in process, and about half of those have been paused for people trying to assess what they're going to be able to do. And those are on the tenant side at the moment. In terms of how transactions for purchase are going, or loans. I mean, I think the couple that I had working at the moment that were through their diligence or deep towards the end of their diligence, both have elected to proceed at the moment. Those are kind of a multifamily deal on some property out of state. And so my experience would be that it hasn't been a complete shut off, but things have kind of slowed as we've gotten closer into April. Sorry. And I, at the moment, do not see a ton of new activity coming in. That's been my experience.
Eric?
Yeah, I'll tell you what I've seen on the litigation side. I've seen a purchase and sale for a significant piece of real estate that was supposed to close on March 30th. And the buyer said, I want to delay. And the seller said, no, we have conditions and we've met our closing conditions. We've met our warranties and reps, et cetera, and we'll take our money. So I'm not going to tell you which side I'm on, but that's a fight. That's a real fight. That's what's happening. I've had one of the biggest problems I've had are in two instances, construction loans, where the developer is unfortunately not being able to move forward with the development the way he is otherwise supposed to, consistent with his loan covenants and his construction financing. And the concern is, what's the extent of a default? Will the lender work with the developers on this issue? And then I have one case where the issue is in the shopping center leases are continuous operation clauses that provide that you got to be open from at least 8 hours from 9 to 10 during regular business hours, and you're not an essential business. I mean, I'm sorry, you are an essential business, but you're still not there. And so do I owe my rent? And particularly when the shopping center landlords are getting their rent as a function of not just a base rent, but a revenue stream. I've had that call, one specific call on that issue with the trouble. So that's what I have seen so far in the marketplace, with a great expectation of a lot more down the pike.
Kevin? Can you hear me? Kevin? Shaking his head. All right. Well, we're going to bounce back and forth between Joe and Eric. Isn't this fun? Everybody's working from home and technology is challenging and all the different software. I've heard Zoom is having connection problems, so that'll be fun. Let's talk maybe tenant landlord a little bit then. So what are the key things should a tenant be considering right now? Let's start with them.
Well, I'll start, and then it's interesting that you've already gotten the call about the continuous operation covenant on the tenant side. Certainly for retail and restaurant tenants, those clauses are going to be prevalent in most of those leases. And I certainly, on behalf of landlords that we represent, I've received from numerous retailers, including national retailers, a letter at first saying, because of the current condition, were excused from the continuous operation covenant. We don't think it's a default. They haven't, not many of them have gone to the next step to say, and I don't think we're obligated to pay rent as a result. I think that's a very interesting question. I think tenants, it's obviously very specific to your particular lease. And so take all this with a grain of salt because every lease is going to be different. But most leases contain a force majeure clause, and I'm sure everybody else has opinions on what those do. But generically, they're built to protect people from situations where performance becomes impossible, to kind of get around the existing common law doctrines or supplant them and put something specific in writing in a particular contract. And it's usually unforeseeable and something that's outside of the party's reasonable control. So I'm not sure it matters whether a lease specifically identifies this current pandemic as a particular item. Maybe other panelists have some thoughts on that. But the big caveat would be, even if force majeure, like what the current circumstance fits into force majeure and definition you've got in your particular lease, most leases don't excuse the obligation to pay rent based on a force majeure event.
Is Kevin up and running?
I'm having some tech issues. Can you hear me?
Yes.
Yeah.
Yeah, I can't hear Joe or I just heard you for the first time now, but Joe's been mute on my end.
Okay, we've got everything showing green on our end. I'll make sure somebody texts you and we can try to work through that. I did get a question here. What about co-tenancy provisions in leases allowing for the abatement of rent for anchor tenants where shelter rule prohibit the other stores from being open and operating?
That's interesting.
All right.
Go ahead, Joe.
Sure, Kevin. If you heard that one, I want to jump in, but I would think that would be a provision that would protect a tenant with a co-tenancy clause, and they would be able to effectively argue the existence of force majeure or not, the absence of that other tenant being open affords the protections they bargained for in that lease. That would be my initial impression of it. I don't know if you think anything different, Eric or Kevin.
No, I agree with that completely. I mean, the whole issue is, have they previously bargained for the risk? And if they've expressly bargained for it in that covenant, I think you're pretty safe. Todd, why don't we go to my slides? Can we do that? So we'll get a sense.
Absolutely. Great place to go.
Here. Okay. In addition to what I put together, and this is short, in addition to force majeure, there's going to be three other kinds of issues that you're going to raise. In purchase and sale agreements, for the purchase and sale of a real estate asset, you'll probably have material adverse change clauses. If you don't have a specific, I should get the feedback, Joe. I don't know what that is. If you don't have a written clause like a force majeure, there are still defenses in every jurisdiction on impossibility or impracticability of performance, or what they call frustration of purpose. So you can get to the next slide. And what you understand is contract law is basically strict liability. I mean, the obligor has the obligation to perform, and early common law did not excuse contractual performance. The whole idea of force majeure was created to fill that gap with two conditions. The event had to be beyond the party's control, and it had to make performance impossible, and I'll get into that. Go ahead. You can switch to the next slide. So you can't imply the force majeure clause. It's either got to be there or it isn't. They are very, very narrowly construed, and in most jurisdictions, only the events listed in the clause will be force majeure. So if you have not listed pandemic or similar language on the face of the force majeure clause, that may not give you an out of a contract performance obligation in a real estate deal or a lease for that matter. You can keep going. Now, some people have clauses that say, well, in addition to a terrorist act, war, embargoes, and other events that prevent performance that are beyond the control of the non-performing party. that won't really expand the nature of the events that can constitute a force majeure, because there's a legal doctrine, a jusdem generis, that says when you have that generic language at the end, that kind of a clause, what it's really referring to means similar events of the type that have already been listed. So that doesn't necessarily get you off the hook just because of the pandemic. Why don't you go to one more slide? Acts of God. Everybody wants to say that the pandemic is an act of God. And it's a decent argument because you couldn't prevent it. And there's nothing you can do about it. And a sudden illness and death and violent snowstorms, I put down cases from Illinois and New York, have indeed been held to be sufficient for acts of God. Although I want to tell you, I think it's going to be very fact specific to your particular contract, because your lease or your commercial buy-sell agreement or whatever related real estate contract you have. And here's why. The pandemic is not permanent. If fire destroyed your, let's not take a fire. If God forbid an earthquake or a missile took a building out, no one's going to make the tenant pay rent. But the pandemic is not going to be an event which causes performance to be rendered impossible forever. So, for example, you may go back to work in 4 months or 3 months. So your performance is only going to be excused under a force majeure, even assuming you can call it an act of God, for the reasonable time period in which one can say, okay, that the pandemic made performance impossible. Next slide, if I have one. So
You might want to quickly, if you can, turn your speakers down a little bit. Might solve some of that feedback.
all right, I'll do that.
I don't know where the volume is.
Let's see if that helps.
Great, thank you.
So it's obviously the party seeking the obligation to perform has the burden. And if they meet the standard, as I said, it only excuses liability in accordance with the express term of the force majeure clause, all right? And may only allow a delay, as to excuse in this situation, because the pandemic is not a business-ending event for performance. And I think the argument's going to be that if you can't perform for 3 months, you may get off for the 3 months, but after that, even though it has otherwise caused you economic impairment, I think the courts are going to say, listen, but we've already given you 3 months, and on the balance here, you took the risk, as most courts say, of economic conditions, and that you wouldn't be able to perform because you have an economic problem. I'm sorry, your business isn't as good as it should be. We're not going to excuse you for the balance of the lease and let you off the hook. I'll turn it over to Todd and Joe.
That's interesting, helpful. I just had a couple thoughts about what you were saying, that perspective on if the pandemic isn't something akin to what's listed in that force majeure clause by that doctrine that you referred to as, well, it's got to be similar to what's already listed. I think maybe another thought would be labor disruptions and supply disruptions, to the extent those are also listed. Maybe these are not, it may not be pandemic specifically, pandemic capital P, but it could be adjacent issues that you can make some use of. And then you also mentioned nobody's going to make anybody pay rent if the building burns down. I think that's a good point. I mean, there are lots of components of commercial contracts, leases, purchase agreements, where the parties have taken some time at the outset to negotiate about specific events that are force majeure but are called out separately, like a casualty. And I think people invest time to deal with that because it's a little bit more foreseen, perhaps, at least it was in the pandemic. And at least in the lease context, it occurs to me those are treated a little differently. They're going to allow people not to insure against it. It seems to me that general context in the leases of force majeure not excusing rent payment gets to places where landlords can collect insurance, maybe to make up some of the loss if the rent isn't paid.
Kevin, are you available yet?
I can hear you. I still cannot hear Joe, so I'm not sure what the
You're not
issue
missing
is.
anything.
Yeah, we're talking
I
about
can
force
see you, Joe.
majeure
You look
clauses.
great.
Yeah.
Yeah, you look like you know what you're talking about. I just can't.
Good. Great. That's good. Thanks.
As long
hear
as the
you.
judge and jury
Yeah,
feel
I'll
the
just
same way, I'm
interject
okay.
what
But
I've.
well, I want to, I have to tell you, I have a client with a lease, a commercial lease with a company in the space sharing business, whose name I will not mention. And the lease is 90 pages, with not including the schedules attached to it. And I think it's going to be difficult for the tenant to say, gee, we didn't think of this, when they probably spent, I don't know how much in legal fees to negotiate virtually every nit possible in that commercial lease. And I think that's an argument that a landlord has that says, what are you talking about here? This is the most negotiated document possible, given its size and complexity and the schedule. And they could have readily included provisions. They included strikes. They included terrorist acts. They included war. I'm sorry, they didn't include pandemics. That's the risk that they took. I don't know that the force majeure will necessarily give that tenant a pass. It may, but I think given the nature, that's why I think each one of these is so fact specific, And I think that's the case where the tenant's going to have a tougher problem with their force majeure clause. They may have other defenses, but I don't know about force majeure.
So are you going to change how you draft leases in the future? Those of you that draft leases? Everything we see from here on out going to include a pandemic clause?
In my case, yes. I think that we'll see this moving forward for sure. I've seen a number of leases since this issue has arisen. I have yet, and I apologize if somebody else has brought this up or made comment to it, a lease that specifically addressed pandemic or any kind of disease-oriented issue relative to the force majeure issue. And I think given the grave results that we've seen as a result of the current circumstance, I think pandemic certainly will be an issue. I think the issue from there will be how you define and describe what a pandemic is. I've seen some debate on that because we've had a number of other viruses and certain, SARS and others, the H1N1. Would those be construed as a pandemic, quote unquote, if you simply use that vernacular? I think defining what we mean by that term will be a big issue in leases moving forward.
Yeah, I'd agree. I think, and I've seen a couple of national retailers that we work with issue updated force majeure clauses that now include pandemic language in their attempt to, specifically toll, especially construction obligations that tenants take on at the beginning of a lease if they're handling the build out. I think that's where going to be a lot of focus on time periods and extensions of time periods before penalties might occur or before rent becomes due if the tenant's handling it. I think it's definitely going to change the way people draft leases, because I think all contract work is kind of accretive over time, right? People just take a look at what's happened and they try and bake new provisions in, and whether they'll work for the next scenario or not, but people cross fingers and hope that they will.
So we went back, interestingly, two things. One is we went back to look at case law that we thought would have emerged from the 1915 Spanish flu pandemic to see how courts had handled the situation, and there's virtually nothing out there. We were very
we saw nothing.
The second thing is, I'm surprised, and I'm talking to the transaction guys, that as a result of that flu, that you wouldn't have seen more over time contracts that it would have included provisions that would have incorporated some kind of pandemic, disease type language to protect people in these kinds of situations, given that experience, which was horrific. But I guess you don't, surprisingly.
Yeah, we looked for the same cases that you went looking for, and also didn't come up with anything. I was surprised that there wasn't something in the past that would be analogous to what we saw. So I don't know why they didn't put them in, but I'm sure they're coming now. We'll just see. Do you you mentioned that Well, I don't know if anybody's seen a transaction yet in which anyone has tried to raise the argument that it's the financial hardship that's tantamount to the force majeure. I guess that's never going to really fly under existing case law, but I don't know if anybody's seen that yet.
That's really creative. A+ for creativity.
Sure.
Yeah, the case law, financial hardship in and of itself is never going to be a basis for getting out of the contract. That's the risk you take. That's the risk the landlord took for an unsecured tenant, so to speak, or a seller took with an unsecured transaction. You know, that's just a risk that they took. That's just not going to do it. The question, though, is, and this, I think you alluded this to, Joe, it is conceivable that the financial hardship was the result of a government edict that caused the in this case, okay, currently, that cut back on a supply chain so that you couldn't get a raw material that otherwise is essential to your business. If U.S. Steel can't get ore, they can't make steel, all right? If GM can't get rubber, they can't make tires. So that's an independent question as to what caused the financial hardship. So I think, that's a tough question too. And again, it's very fact specific. These are going to be real fact specific cases. I haven't seen that yet though, but I think it's going to be there.
Do you all want to touch on doctrine of impossibility of performance and impracticability or frustration of purpose?
Sure. Go ahead, Joe.
Well, I was going to defer to you because your slides went to it. I mean, my general understanding is, and maybe you can correct me on it, that so impracticability, impossibility, old common law doctrines try and excuse performance when it just becomes almost impossible. But as, I guess by the term itself, but as Eric said, it's a very high standard and perhaps doesn't provide the protection that people will be looking for. I think there's an analog. I'm thinking just in real estate contracts, but I know there's an analogous provision in the UCC for contracts for goods that uses the term impracticality or impracticability. I think that's a slightly lower standard than what may have been applied at common law in the impossibility doctrine. And on frustration of purpose, I think that goes more to the intent of the parties as to, did both sides understand that the purpose of the contract was to do X, and if that's frustrated, then maybe performance is excused by that doctrine. But as Eric said, and I don't want to just regurgitate it, but these force majeure provisions, I think, were created because lots of contracts have long durations with multiple promises about performance to be made on both sides. And the durations of those contracts far exceed anybody's ability really to forecast what's happening. I mean, most leases 5, 10, 15-year lease. And I don't know, anybody who has a modeling or forecasting that's accurate over more than 2 years. I mean, that's amazing. So these provisions exist, I think, to provide relief and buffer for people in situations. It's the unknown unknowns that maybe are not worthwhile to spend the time at the outset negotiating over, but just to try to get some sort of baseline protection were they to occur. So that's my take on those doctrines. But Eric, I'm happy to hear yours.
Sure. I think it's really important for everybody listening in to understand that a force majeure is a contractual covenant. The co-tenant covenant was a contractual covenant, and they're going to be governed by typical, contract interpretation provisions and the facts and circumstances of the situation. But no matter what side of the transaction you're on, the obligor, the person who owes the duty of performance in the real estate deal, or the tenant, or the developer with the landlord, with the lender, or the general to the owner, or the sub to the general, they can make an argument on something called either impossibility of performance or impracticability of performance. And, the general rule is that the obligor bears the risk if a contract becomes more burdensome. You see cases all the time where the court says, listen, I'm not, in the 2008 to 2010 Great Recession, tons of people went to court and said, I'm broke. I got killed. And the courts consistently said, listen, that's very interesting. I'm sorry. Okay. But we're not here to reallocate the risks in a contract. And you're stuck. I'm sorry. And that's the typical rule. Obligor bears the risk, just because a contract becomes more burdensome or less desirable. But these other doctrines have arisen, and impossibility of performance, in different states call it, in Illinois, they're the same, impossibility and impracticability. Delaware makes distinctions between the two. So it's very state by state specific, okay? But it has to be an objective test typically. And what this means is it can't just be, I can't do it. It's not impossible because I can't do it. It's impossible because no one can do it. So clearly the event which triggers impossibility has to be something that you can't do. And it could be an act of God or an act of third parties, even though the specific act isn't included in your force majeure, so that, as I said, a severe shortage of raw materials or a disrupted supply line or an embargo or even a local crop failure because the locusts came and ate up all the crops. I mean, these things can be impossibility of performance, but once again, the impossibility or impracticability only will last as long as the triggering event occurs. These are not contract killers by any stretch. And lots of courts, as I said before, financial distress or the inability to pay is not going to work. But the fact, if you don't have this in a force majeure, or even if you don't have a force majeure, if the government shut you down, that's going to be an impossibility of performance. Government regulation order. There is case law to support that all over. So a big issue for me, and this even includes for force majeure, is are you an essential or a non-essential business? Okay. Let's assume you're an essential business and you're a tenant, but you decide just for your own health purposes and in good health behavior to tell your employees, don't come to work, okay? We're going to shut down, and because we don't want you interacting with each other or people in the mall, et cetera, or people who come in the shop. Does the commercial landlord in the shopping center says, well, that's great, but you weren't an essential business. You didn't have the right to close. You could have operated healthily, so to speak, or in a manner, everybody wore masks and gloves, et cetera, and controlled it. So those to me are going to be key issues because there's going to be fights over whether or not you were in fact an essential or a non-essential business. If you're a non-essential business that was in fact closed down, I think by the government, I think you have a good argument to get out of a contract, even in the absence of a force majeure.
I think that's interesting. I think about contractors, and they are, currently essential services, right? But it may not mean that they can continue to perform exactly as they could have before the pandemic. I mean, the distancing required, how do you get people into a freight elevator? How do you carry heavy glass? What happens if someone tests positive on the site? What is that going to do to contractor performance as they have to spend time then cleaning and trying to get things back in order? And what happens when people just decide they're not going to come in, even if the employer is not saying you can't come? But I mean, that also turns on the specifics of your contract covenants and what kind of relief you may have bargained for there. But I think it'd be important for anybody in that situation to try and document as best they can, kind of keep the best records they're able to about what they're really experiencing, so that if they need to make a claim or press their rights, they have documentation to show this is what actually happened.
Well, I think that's a good idea. I have to tell you, if I was the landlord or if I was the obligee, the person to whom the performance was due, and depending on the your particular financial situation, and I'm not here to speak to that, and you believed that the obligor has defaulted, I would still send the default letter and reserve my rights. Because if you don't send the default letter, there may be the argument that if you let it go long enough, that you somehow impliedly waive that the conduct was okay. That doesn't mean you have to, even though you call the event of default, I'm not suggesting that depending on your negotiations with the obligor, you have to enforce it, okay? You can clearly accrue the liability. You could spread it over the rest of the lease term. You can otherwise renegotiate in such a way, but I still would protect myself absolutely and call the default for what it is and make sure everybody's positions are staked out. So it doesn't get sloppy later because someone said latches or some kind of implied waiver or an estoppel. We relied on you. So I would definitely call my default for sure.
Right.
Preserve your rights. I would do that.
Yeah. Do you think that a failure to call your default could be something that could get you in trouble under your loan, as maybe a tantamount to an impermissible modification of a major lease? If the tenant that is saying, all right, I can't pay, you write a letter back saying we acknowledge circumstances are unforeseen. However, and you attempt to work out a deferment with them in some way. I think there's a concern, at least the clients we're working with, that they need to be cognizant of what their loan document says, what maybe their non-recourse carve-out guarantee says about making them, when the lender's consent is required to that sort of modification, allowing a deferment, and to get it right before you do anything to trigger possible liability with your lender beyond your difficulty in paying. So,
absolutely, I agree with you. I agree with you, and that's what you're going to be doing for the next 6 months.
Yes,
negotiating those.
Right.
I mean, let's face it. Why do the landlords? Why do the lenders? Why do the obligees, the people to whom the obligation is owed? Why do they have to take all the hit? I mean, they're getting hit too, just like everybody else. That's the court's problem. Is going to say, gee, why does the landlord have to suck up all the losses here? It goes downstream to the banks and or whoever the lenders are.
Right.
So these are tough issues. And for example, I have one client who is being what I believe to be very gracious with its obligors to spread out the obligation over the remainder of the lease term, to amortize it over the remainder of the lease term. And when we talked, I mean, the reason is look, I need these people. When this goes away, I need these people.
Right.
I need the mix of tenants. I need the relationships. And I hope it comes back in a positive way. I can't just throw everybody out.
Right. How quickly can I find somebody else to do the same thing? Right.
And I go to my lender and I can say to my lender, look, this is what I'm doing. And you give me the same kind of break and we can work this all out, because hopefully I thought it was Easter, according to the president, or some other time thereafter, we're going to be back trying to get this thing moving up again. Maybe it's 1 month or 4, whatever it is. You don't want to kill the relationships, and that's key. That has nothing to do with legal. That has to do with business. And you'll be doing a lot of that, I'm sure, too. Lots of that.
Yeah, I wanted to transition into that practical advice. So what are the things you're telling your clients if they call and just say, what should I be doing right now?
Well, I'm going to echo some of the things that Eric just said, but when we get letters saying, we think there's a force, the government mandate requires us to close, we think that's a force majeure, we're not going to pay rent, I think we, respond with, counsel our clients to send a letter back saying, we understand it's unforeseen circumstances. However, you still are obligated to pay rent. I'm not sure if they're going to call defaults yet, but it's going to be the next step just to preserve rights. I think the other practical advice, not to just tread over ground we just talked about, was to take a look at your loan documents, make sure you can make the adjustments that you'd like to make for a tenant you're trying to keep without lender consent, or if you need it, go get it. In some cases, I think landlords, there's a variety of different letters we're sending out for people. And one of them is kind of a question about, from a landlord's perspective, are we the only people you're asking for relief? Please let us know what specifically is going on with you. Send us your financial statements. Please let us know who else you're asking for relief. And have you tried to make use of any of the recent government programs to provide additional funds to kind of start the conversation about how about what is going to be deferred and what isn't.
Yeah, those are good points. I live in a different world than you do, so I always think of worst case bases, and that's why I counsel to send the default letter, but to reserve the rights. But the other practical issue is, I think the obligor would be entitled, if they get these inquiries, to ask for adequate financial information to really understand the obligor's financial condition. Some people if it's Microsoft calling me up asking, or Google calling me asking for help, I'm going to say, well, wait a second, you guys got a lot of money in reserve and you're still doing a lot of business. So, I think we do have a fair right to request for adequate financial information to support the claim. And I'm not talking about taking your clothes off in detail, but I'm just talking about some basic stuff. And then at the same time, I think everybody, and I'm not going to opine on this publicly to a lot of people, but I think the big B word has to be considered, and it's called bankruptcy, because I know it's not something that everybody cares about, but a Chapter 11 reorg can be helpful, not just to the tenant or to the obligee, but in certain circumstances can be helpful to the obligor, and particularly if you do a package Chapter 11. And I think it's imperative under these times that people in the real estate industry, particularly, because real estate is unique in bankruptcy. It's a different kind of an asset than purchase and sale of a good. So we could have a whole different panel discussion on this, but I think it's incumbent upon everybody in the industry on both sides of transactions, all counterparties, to become very conversant and informed, at least, about what the implications of bankruptcy are on your business and the particular transactions that you're involved in. I think it's very, very important, and you're naive to avoid it. People don't like to put their foot in it, but it's important to do.
Can we build on that for a second with a question from Peter Carlos? I hope I'm not hacking your name up, Peter. But talking about the payroll protection program, CARES Act money that's out there that says it's for paying rent. So would a landlord have a case that they have needed to make a good faith effort or to at least try to get their rent covered? Or how is that going to affect some of these negotiations?
I think it's my understanding is that there's some funds you can use if you get the PPP plan loan, that you can use a portion of those proceeds towards non-payroll costs like rent. I think it's these things tend to change, and I'm sorry if I'm late on it, but I thought it was capped at 25% of the proceeds.
Yeah, that's the latest.
Yeah, so I think I guess if the question is, should a landlord? I was thinking of it more from a perspective of before a landlord were to grant somebody relief. Without even asking if they've applied for this and may have some funds available to make rent payments because of the program. I think that would be it. And I'm trying to think if the question might be styled, can the landlord make use? Well, they can certainly make use of it if they qualify as a small business and have employees. But I think it fits best in the context of if the tenant's asking for relief, have they tried to make use of that? Do they have access to those funds? Maybe that helps them to, the disclosure that was discussed, maybe that helps figure out really how much relief they actually need at the moment.
Yeah, Peter, that's a great question. I would say the following. First of all, the force majeure defines the triggering events that you can use to get out of the deal. So either you're in it or you're not, given the facts and circumstances of your particular business and your force majeure clause. But in terms of using defenses like impossibility of performance or impracticability of performance, it is very clear that if you could have taken advantage of the CARES Act and it could have provided you with economic relief to mitigate significantly or to a great extent the burden that you're otherwise suffering, and you fail to take care of it, I believe the argument would be is that you cannot claim an impossibility or impracticability performance because that is not there's not an objective reason that you can't perform it because you could have gotten some money for it. In other words, again, the standard is it's not that I can't perform, it's that it's impossible for me to perform. It's that it's impossible for everyone to perform. And I think if you fail to mitigate that way, I think it would be very difficult to argue impossibility of performance if the obligee could show that, look, had you done that and it was available to you, you would have easily have had dollars that you could use to pay me. Likewise, on the flip side for the obligor, if they apply for the CARE Act and they don't get it, okay, or they get so little, then that's a different argument. But that's an excellent question. Excellent question. And that's not just going to be true for the CARE Act. That's going to be true for every single other government program out there, including state programs that are starting to crop up and additional federal programs that are available if people don't take advantage of them and they otherwise could. That's an excellent question.
Well, let's pivot a little bit to then, is there a need to file an insurance claim? And I got to tell you, we're in the event business. So our company, RE Journals, a lot of our revenue comes from holding live events. We made a claim to our insurance company that for business interruption insurance. But how does that apply to this landlord-tenant scenario?
Go ahead, Joe.
Well, I think generically, and you could probably correct me, but I think business interruption insurance is usually found in your property policy. And it's going to, at first glance, most of them are going to require damage to the premises that you're trying to make use of. So that makes it the argument tougher, I think. But some policies also have kind of government authority endorsements, which may apply in this situation. I'd be interested to hear Eric's thoughts on it, but my understanding of that is that it's still a requirement that you're prevented from accessing the premises you need to conduct your business, because some other property has suffered physical damage, and as a result, the government authority has said you can't access your property. You know, for example, a tornado tears up things adjacent to you. It's no longer safe for you to go into your building. It's possible that every insurance policy is a contract just like anything else, and it could be written in a different way. And it would be wonderful if you had a blanket provision which said if you are prohibited from using your premises because of the action of the government authority, then it's a covered event. That would be great. I'm not sure all policies work that way, but that would be my initial view on it. What do you think, Eric?
I agree with you. I think it's going to be tough unless it's property-specific damage that results in the business interruption. But I'll echo, I think that's what he was trying to say, that every policy is different with different carriers and their endorsements and what you paid for. And it's also state-specific because insurance is very state-based. So as you know, there's no federal insurance, common law. It's going to be state-based. So you should talk to two people. One, you should talk to your agent or your broker, and then if you have, depending on the nature of the organization you should talk to coverage counsel for that kind of a thing. But it's an important question. I don't think most law firms have business interruption insurance, but maybe they do.
We didn't think we had it either. Kudos to our CEO who bought business interruption insurance. We'll see. I'll keep you in the loop if we get anything.
Yeah. Great.
So this is a good question, kind of a fun one. Rick Lynn, when will we expect the flow of workout loan opportunities to start kicking in?
Oh, wow. That's good. Go ahead, Joe.
No, I took the first one. I took first try last time. You go ahead on this one because I've got my own view, but
I'll say starting the beginning of June.
Really?
Yeah.
That's soon. Default notices and all the timing things that have to happen?
I still think the beginning of June.
That's
a lot of work on activity.
Yeah.
Yeah, I think that's a good estimate. I think it depends upon who your lender is. I think there's a lot of banks who are able to give a 90-day deferment, without engaging in formal workout discussions. But after that initial 90-day lapse, maybe then we'll see a real kick up in that. So that's April, May, June. So maybe I'd say July, but it's got to be close to June.
Yeah, I don't think it's the lenders who are going to push it as much as the borrowers.
Right.
Who are going to
come back after the 90 days and say,
I appreciate the 90 days.
Right.
But to get my supply lines back up and running, I got to rehire. A lot of people have fired employees. I got to rehire. I'm going to need cash for that. I need working capital. Where am I going to get that working capital? I need lines of credit. I think they're going to be knocking on the door, and I think the lenders are going to say, for example, to avoid bankruptcy, which is not going to help me. I don't want these properties. What are the lenders going to do with all these properties? Right. Sell it to some fund out of Greenwich, Connecticut, or Stamford, or for distressed real estate. I mean, that's what they're going. I don't think they want to do that for pennies on the dollar, which is what happened in 2009 and 2010. I think they'd probably rather work out a deal to keep this property, on their books rather than REO or real estate owned. That's the last thing they want.
Yeah, for sure.
So I think they're going to be working it out sooner rather than later. Excuse me.
We have a question from Paul de Kruff. That's over my head, so I'll ask it as he wrote it. What will happen to cure provisions costs, say, on multifamily CMBS loans when cities and states are mandating eviction moratoriums, so no evictions? Cure provision
costs when states are preventing evictions.
So are CMBS loans going to blow up, or what happens to that? I'm assuming what he means.
Okay. Well, I think the analysis is kind of the same. I mean, people are going to have to knock on the door of even the CMBS servicer and say, we need to discuss a forbearance because of the current conditions. And how the evictions, I mean, I guess that'll be part of the conversation they have. Like, not only can, I have problem tenants now, but I can't remove any because of the current backlog. So it's going to take even longer for me. And so that'll probably factor into the workout discussion as to how much relief they're going to get and with the timeframes.
Yeah, and we've all been through this with CMBS loans. We know how difficult it is to negotiate with someone who may or may not have the authority to negotiate. I'm hoping a lot of that got worked out in 2009, but you never know, right? Anybody else that has questions, make sure you include it in the chat section. Gentlemen, Joe or Eric, do you have anything you want to add that we missed?
No, I have a question about the real estate market. This is not there's been I don't want to say a movement, but in what I'll call the multifamily side, all of a sudden we're having these, what I'll call co-share buildings where you don't rent an apartment these are for like people who right out of college until they get a more established job, like from 22 to 30, you rent the room. And you can rent the room, and that way you pay a fee for the common element to use their gym or whatever. And you can move from room to room, and that way you don't have to worry about, 4 people renting an apartment and somebody leaving, and then everybody else is stuck with the rent and the phone bill. And I wonder if as a result of the economic consequences here, we're going to see more of that at a higher age, at least in multifamily rental, that people don't want to rent full apartments, so they're going to rent smaller units. Unit size is going to go down. That's a business issue for another panel.
Yeah, I wish I had the answer to that because that would be a great thing to be that forecast. We wouldn't be doing this anymore. That'd be great.
Yeah, it's interesting.
Yeah, it's going to be interesting to see what happens with real estate. We'll keep having webinars to cover all of these topics you all think of. So again, in the chat room too, if you have another topic or question that doesn't necessarily fit in here, we'd be happy to find an expert and make sure you get answers to those things. We know that you value the ability to get together as an industry, and that's been taken away from us. So we'll try to fill that in if we can. Let's see here, make sure we got everything on the poll. So you guys maybe didn't notice, Joe and Eric, but I asked people about their pets. Are your pets happy that you're home now that you're working from home, or are you thinking about a COVID puppy? My family went out 2 weeks ago and got a St. Bernard puppy, so we got a hair and drool all over, and everybody's happy to have somebody to play with.
That's great. That's good. Good for you.
Well, here's the last one. Let's get this one in. Seniors housing. With lots of common space, what are some of the issues seniors housing people are going to have with their legal leases and contracts?
Well, just generically, like you just said, with the common space, is there any liability people at the greater policing efforts, I guess, to try to keep the separation, the required 6 feet, and close down some of those common areas? I mean, parks in my town have got caution tape up around them so that nobody can go use the park equipment for kids. That you can still take a jog through it, but you can't get into the kind of more dense spaces. So maybe that same sort of restriction and limitation, and whether that makes people claim, well, now I shouldn't pay the same rent because I can't use the same things. It's quite possible.
Well, I'll talk about the litigation side. All right. And unfortunately, I think you're going to see two things. First, I think it was the day before yesterday in Illinois. This is the first case I saw where the individual who unfortunately suffered coronavirus and was a Walmart employee, the estate has sued Walmart, claiming Walmart did not adequately maintain safety for that individual. And I'm not here to opine whether on the merits of the claim. But I can readily see in the senior centers where seniors are passing away after a time that a senior center had adequate notice of the virus and ability to take protections, you will see similar types of litigation. And if it is a senior facility that is a nationwide organization that has like those life contracts, for example, particularly contracts where they get medical care in addition to just senior living, taking their blood pressure, giving pills, whatever, taking them to hospitals when they need to go to hospitals, whatever. Next to hospital or
Well, we got a frozen screen for Eric. It's 1:50, so timing's not too bad.
I just said I think you're going to see class actions on those kinds of claims.
Oh,
unfortunately, it's just going to be there.
wow, scary stuff. I hate to hear that word for any kind of a landlord or anybody on either end. Let's go one more quick one, and it looks like this is going to fall on you, Joe, because I got a picture of Eric frozen on my screen at least.
Okay, fingers crossed.
Someone wanted an explanation for frustration of purpose.
Okay. I'll take a crack at it, and then Eric, you can correct me if I miss it. But I think that is an old doctrine where the idea was you had to show that both sides knew the intent of the parties to the transaction, and that if that could no longer be accomplished, then that would excuse performance. I think the classic case, trying to think back to law school, is where someone rented a room in New York to watch a parade for a day, and the parade was canceled. And so the landlord still said, well, I still want my rent for that day. And the renter said, I should have to pay it. The purpose was frustrated. I could never have made use of it for the reason. And the landlord knew that's why I was doing it. And I believe that's the doctrine, and they prevailed in that case. Whether that would apply to commercial leases, like the 90-page leases that we've got with specific provisions about no excuse for rent payment, and whether even the existence of your force majeure clause will block arguments about impracticality or frustration of purpose because they aren't in the contract, but the force majeure is, and that's what people should look to. I think that's an interesting question.
I don't know, for people out there who care, if you look at the section 265 of the restatement second of contracts, it will give you the definition, and it really is very similar to the doctrine of impossibility and impracticability of performance. I would say the difference, as I see it, is the frustration of purpose, or commercial frustration it's called, focuses on the intent of the parties as to the benefit or the basis of their bargain. And whether that, which is similar to what Joe is saying, whether the basis is something that you hadn't bargained for in such a way that the purpose of the contract is frustrated. But they're very similar, the doctrines, very similar.
You get an A+ for looking that up. All right, so we're out of time here. What if you're online and you want to enter something in the chat room with a question? I will forward those questions to these gentlemen, and they will get everybody's email address and be able to address them to you all or to somebody specific. So if you have a question, you can stay online for the next couple minutes and get that done. But thank you very much for this. Thank you for allowing me to sort of dork out and remember my law school days and try to think of some of these things that people haven't thought of for a long time. And you gentlemen were very informed on that. So I appreciate it on behalf of Real Estate Journals. And thank you again.
Yeah, thanks for having us. Enjoyed it.
Parting words.
Stay safe and stay healthy.
Yeah, y'all too.
Okay,
Thanks.
I'll stay online for a minute and let you ask questions. Thanks, everybody.
Bye.
You can log off if you want, Eric. I'm just keeping the screen up.
Okay, guys. Thank you
Great.
very, very much, Todd. I
Thank
really
you.
appreciate this.
Likewise.
So,
Thank you.
It was a pleasure to meet you.
Yeah, nice to meet
Likewise.
you as well. Thank you both.
Right.
All right.
Right.
See you.
Africa,
Bye.
the vagaries of technology. Later.